right now with the Civil Rights Act of 1964, because that's the basis for almost everything that we see in terms of discrimination. Now, how many of you, when you were in high school, maybe even in college, read Upton Sinclair's The Jungle? Only 2 people, 3 people, wow. If you have a chance to read it, it's a great book looking at the meatpacking industry in Chicago at the turn of the century and how bad of an environment it was. And people would fall into the chutes and they'd be swept away and killed just like the cattle. They didn't really care about it. And it's just the whole idea of what rights do employees have. And it wasn't until the 1960s when we started taking a look at the workplace in a more formalized process that we're trying to look at what could we do to make it easier for people in the workplace so they don't face hardships. Because you could be the most talented individual, but if you're not given an opportunity, that harms the economy. So the Civil Rights Act was passed in 1964. It's administered by the EEOC. If you have 15 or more employees, so if you have 20 or more employees, that's still, you have over 15 employees. The exception is for private associations. If you are a church, a synagogue, or a private club, they still allow you to discriminate. And the reason why it's 15 or more employees is that there could be ma and pa kettle, who have their KKK banners are us, and they sell banners or hoods for the KKK, whatever it might be. If they are a small company with 3 people working there, they can discriminate. And the courts will uphold that discrimination, and the law was developed in such a way that they don't want to impose themselves, the government, on someone that's going to be a small organization, because why would anyone who's of sound mind want to work there anyway, if they're a minority or if they're Jewish or immigrant or whatever kind of thing. So they didn't want to force that on people. So they said, if you're a larger institution, which meant 15 or more people, you have to follow these laws. And what do they protect? Race, color, religion, country of national origin, and sex. These are often called immutable characteristics, which means they cannot be changed. But as we know, you could change, well, Michael Jackson was trying to change his color. I don't know if that worked. But you could change your religion, because you could convert from one religion to another, right? So that's not immutable. The country of national origin, you cannot change that, but you can change your sex. So these aren't necessarily all immutable characteristics, but they are something that would be overtly out there, where someone could take a look at this and say, look at, you know what? I don't want to hire that person because they're X or they're Y. And that's what we're trying to do, is overcome this initial hurdle for getting or keeping a job, that it's not based upon just someone's background. And that's what all these laws were developed to protect. Now, there are 2 primary theories: disparate treatment, which is intentional, and disparate impact, which is unintentional. How do you prove a case? The case is called through prima facie. Prima facie is called first blush, like the first blush of the face. You have to have, as required here, you're part of that protected class. If you're not a member of a certain race, you can't prove that you are discriminated against. That doesn't prevent reverse discrimination, such as the Bakke case, where a person applied for medical school and he was otherwise qualified, but he was rejected and they took a minority in his place, and he sued, and the Supreme Court of the United States, this is 1976 if I remember correctly, said, yes, that's reverse discrimination. And this is something that has been going on in a lot of universities throughout the United States still to this day. How do you provide benefit for minorities, but the same breath, not harm people who have done the job that they needed to get into an institution? And so there was a recent lawsuit involving Michigan involving the same issue. So the courts are still dealing with this almost 40 years later. So prima facie case, prove membership in the protected class. You applied for the job or were doing the job well. You were qualified you're adversely impacted and the employer filled the position with a non-minority, or continue the search saying, hey, we're going to keep looking. That's minimum. You need to be able to show that in order to get past the initial hurdle that there in fact was discrimination. Then it switches to the employer side where they could prove, if possible, a legitimate non-discriminatory reason. This is where that BFOQ, the bona fide occupational qualification, might come in. If you could say, hey, look at, you know what? We were looking for someone that is this type. So you could do that in certain things like acting. Well, this role we had looked for X kind of person. Or if it's the Sports Illustrated swimsuit calendar. If I applied for it and I didn't get accepted, can I sue? You know, well, this becomes an issue, you know, because should they have men in there? You know, what's going on there? There actually have been lawsuits against Hooters by men who said, look I applied and I wasn't hired. And they sued, and that's why they've put men as greeters at some of the locations. I'd hate to be at a Hooters where a guy is wearing something up to here with hairy chest, serving me food and stuff like that. There might be health code related issues and other concerns like that. That's kind of thing where you might say, is there a legitimate reason for this? And even if they say this is our legitimate reason, you can say basically BS. What is called is pretext. You're just saying that because you want to avoid potential liability. So whenever we look at these cases, you want to take a look at, can you prove this prima facie case? So when we look at, and it's covered with ADEA as well, for Ageist Women in Employment Act, they look at the same kind of things. Are you over the age of 41? Were you replaced by someone that was younger? And you were doing your job well and everything else? That's the kind of things they look at. And then you have to be able to, as the employer, say, well, here's the real reason why we got rid of you. We see this oftentimes when someone is terminated. That's when you see this most frequently, is that, let me ask this question. If you're terminated, are you owed a severance package? If it's under contract, maybe. But if you're an at-will employee, no, you're not owed a severance package. You're owed any vacation time or sick days, things that you've earned, but you're not owed a severance package. What the courts will take a look at is, why are you doing this? Well, you're doing that to buy their silence, so to speak. Because when you sign a release that you accept 2 weeks extra pay or whatever it is, you agree not to sue them for any wrong they might have done to you. They're not going to give you any money unless you sign a severance package. And they have it strictly in there that under the ADEA, you're supposed to have a certain number of days within which you can review whether or not you want to accept it or not. And if you've accepted it, you can reject it within a certain number of days as well. All is a way for someone to see, what is the company actually doing? And if the company has now discriminated against, you can say, hey, look, here's your money. I don't want your money. I want, my rights back, and then you can go after them and sue them. It is a battle because sometimes you're scared to terminate someone because you don't know if they're in fact going to sue you. That's why what I tell everyone when I'm giving them advice is say, make sure that you have an ironclad reason to terminate someone, and you have that way before you decide to terminate them. Have it all prepared, and then you terminate them when you have all your ducks in line. Because otherwise, you could make one simple mistake. Say, look, you're doing a great job, but I feel so sad I have to let you go. Well, are you going to replace the person? Why are you doing that? All of a sudden, they might feel like, well, it's something with me, and this is why you're doing this. And so it's a very sensitive kind of issue, that the whole process of termination, what is used. And so that's why when we start taking a look at this, BFOQ and all these other criteria, it's all designed to look at how can we protect ourselves as an employer to minimize the likelihood of someone suing me at a later date. And then you do the release afterwards when you give them the severance to say, this is why I'm trying to buy my freedom of mind that you're not going to sue me. Not everyone's going to sue. Some people will be discriminated against and will say, look, I'll take my lumps and move on. Others will not, and they're going to want to have that pound of flesh. There's also people who don't want to terminate someone even though they rightfully should because they're scared about the legal consequences. I mean, my mother-in-law, when she retired from working in the computer industry, she was probably about 73. They weren't going to touch her. She could work as long as she wanted there because here's an older woman, in her 70s. Of course, if you replace her, who's it going to be? Someone younger. They can't go out and try to, let me find us another old person to fill this job. No, and she was highly qualified, highly paid, but that becomes an issue that they try to figure out sometimes. How do we process this? Whenever we look at these claims, you always want to look at, is there any type of retaliation that might go on? If someone claims that there is discrimination in the workplace, that goes on a regular basis, and you have to make sure that's included in your employee guide, that if there's any retaliation against someone for raising a claim, whether it doesn't have to be discrimination, it could be a workers' comp claim or anything else, any retaliation is considered a violation of public policy, and that is not grounds for termination. So you got to be very careful. If someone in fact retaliates, yeah, you can terminate them, but you can't try to retaliate yourself as the employer against someone who files a claim. So you got to be very careful with that fine line. Defenses, the bona fide occupational qualification is probably one of the biggest ones that we see out there. Now, there are a number of different laws out there, like affirmative action, which we see like with the Rooney Rule. And the question becomes, in sports, is that in the best interest of the game? Because what happens is they'll bring in some minority candidates without the intention of actually hiring them. Because the NFL says you have to have at least one minority candidate that you interview, and they'll have the same minorities going to all these different job interviews, and if they had no intent to hire them, I think that's the bigger shame. That it should be, qualification is, if you're the best and qualified, you should have equal opportunity and right to it, and if they're just doing this as a token to make the league feel happy or something, that is a problem, and I have a lot of issues with that. Excuse me.